Case 42. Piper Aircraft versus Rayno. We find ourselves at the Supreme Court of the United States. Facts. On a charter flight from Blackpool to Perth in the UK, a commercial plane crashed in the Scottish Highlands and killed its 5 passengers. Rayno, the administratrix of their estates, brought wrongful death claims against the manufacturer of the plane, Piper Aircraft, among other defendants. The action ultimately was transferred to Federal District Court in Pennsylvania, from which Piper sought to dismiss it on the grounds of forum nonconvenience. Most of the witnesses and evidence were located in Scotland. However, Rayno argued that Scottish law was less favourable to the plaintiffs than Pennsylvania law, because it did not include the doctrine of strict liability for these tort cases. The appellate court agreed with her and reversed the initial district court decision granting the motion to dismiss. So what's the issue? Whether in an action in federal district court brought by foreign plaintiffs against American defendants, the plaintiffs may defeat a motion to dismiss on the ground of forum nonconvenience, merely by showing that the substantive law that would be applied if the case were litigated in the district court is more favorable to them than the law that would be applied by the courts of their own nation. And whether a motion to dismiss on grounds of forum nonconvenience should be denied whenever the law of the alternate forum is less favorable to recovery than that which would be applied by the district court. So the holding. The court held that the prospect of an unfavorable change in the law does not justify dismissing a claim on that basis alone. Let's look at the reasoning. Rayno candidly admitted that the action against Piper and Hartzell was filed in the US because its laws regarding liability, capacity to sue, and damages are more favorable to her position than those in Scotland. Scottish law does not recognize strict liability in tort. Moreover, it permits wrongful death actions only when brought by a decedent's relatives. The relatives may sue only for loss of support in society. Let's look at this chart. So, the ties to the United States are that the aircraft was manufactured by Piper in Pennsylvania, and the propellers were manufactured by Hartzell in Ohio. On the other hand, let's look at the ties to the United Kingdom. The crash occurred in Scotland. The decedents were all Scottish. The aircraft was registered in Great Britain. The aircraft was operated by a Scottish air taxi service. The aircraft was owned and operated by companies organized in the UK. The wreckage was in England, and witnesses who could testify regarding the maintenance of the aircraft, pilot training, and accident investigation were all in Great Britain. And all damages witnesses are in Scotland. The doctrine of forum nonconvenience may be used to dismiss a case if the plaintiff has no specific reasons of convenience for its choice of a forum, and that choice places a heavy burden on the defendant or the court. Unless the remedy provided by the alternative forum is clearly inadequate or unsatisfactory, such that it is essentially no remedy at all, the prospect of a difference in the substantive law should not receive substantial weight. It never should receive controlling weight. In this situation, the remedies provided by the Scottish courts are not inadequate, even though the lack of a strict liability theory might reduce the size of the damages award. The plaintiff still would not be completely deprived of a remedy or treated unfairly. Let's talk about the administratrix for a moment. An administrator refers to a person assigned to administer a probate estate. Administratrix is the feminine form of this term, as Gaynell Rayno was the administratrix of the estates of the 5 passengers in this case. Rayno was not related to and does not know any of the decedents or their survivors. She was a legal secretary to the attorney who filed this lawsuit. Several days after her appointment, Rayno commenced separate wrongful death actions against Piper and Hartzell in the Superior Court of California, claiming negligence and strict liability.